2017. I am Peter Kaczynski. To my right is Douglas Kellner. To my left is Greg Peterson, and to my far right, Andrew Spano. These are the four commissioners.
How come he's not far left?
Because you're farther away from me.
Totally inaccurate.
Switch places.
We'll start the meeting off with the minutes of April 25th, 2017, which I believe all the commissioners have received. Is there a motion to accept?
So moved.
Second.
Moved and seconded. All in favor?
Aye.
Opposed? Okay, so the minutes are adopted. And now we'll move into the unit updates. And we'll start with the executives, Robert Brehm and Todd Valentine.
Yeah, there's two main things I wanted to point out to you. We've been meeting in response to the last fall's election and looking forward with the presidential or the Homeland Security designation of elections as critical infrastructure. What we've been doing is analyze our own self, and we're prepared. We've been working with a vendor, Nysboe, or one of our security vendors, to help us develop a risk assessment for the county boards. It's something that we raised with them, that we plan on sending out a survey to try to identify how we're at risk and they're at risk, and how the two go together. So we're planning on sending that out June, this month now, and then have a follow-up with the counties, and then get the responses back. And then, of course, we're going to do our own assessment later on in the year to figure out, beyond what we've already done, to figure out if there's further resources we need that we don't already have, that we have to ask for in the next budget year, that we don't already have in this budget. So that's, and it's all in preparation to try, do as much as we can between elections so that we're ready for the next election event, so that we can, learn from past vulnerabilities that we've had or incidences that have occurred. And that also relates to, we are sending out, a number of the staff are going to the County Board Election Commissioners Conference, which up in Lake Placid at the end of June, and we're going to prepare to make our own. We're on the agenda for a couple of events, a couple of sessions, so we're going to start planning, have those presentations ready, in the next, probably starting next week, that we haven't already thought of. So, Bob, do you have anything to add?
A couple of items. Besides the cybersecurity one, Nysboe is in the room. They're sitting in the back behind IT Director Cross. Also joining us on that risk assessment to make sure that we at least cover important topics. We continue to have the assistance of Peter Bloniars, who's the Executive Director and Senior Policy Advisor for the New York State Cybersecurity Advisory Board. Long title, but he's been very helpful to us on, it's tough because it's a broad topic. We could get very far into the weeds, but I think we have a limited budget, and we want to at least try and do as much as we can with a resource to at least start with a risk assessment and see if we can lay out a path going forward. If we try and do too much, we might not be able to provide any kind of guidance. So we're really starting with the risk assessment. It'll cover survey questions to the county, and most likely those will lead to follow-up questions to the county. We hope to finish getting that survey ready in time for the June conference, so we will use the new web conferencing equipment to reach out to counties before the conference and also do the presentation at the conference. So we're putting the counties at the front of that queue because we know that this is the local election year and they're going to get very busy as we get closer to October, November. And then we're going to put the state IT risk assessment in that second phase. So while they're busy running the election, because this is their busier season than it is for us, we will then spend our resources during that busy time for them doing the state portion of that. So it's a two-phase. We hope somewhere around January 1 or the end of December to have that first recommendation or report ready, best practice advisories. The other item, we did receive May 22nd from the New York State Attorney General the required advice for the two propositions or proposals that will appear on this year's ballot in the form that the Attorney General gave the advice to us. We posted that to the website and put a link for people if they were interested in giving us comments. We have received several comments so far, either before we got the advice from the groups associated with the lawsuits that we've had from Evan Davis.
Now, Bob, when you use the word advice, you're talking about the form that it's going to appear?
Under the statute, the Attorney General opines on the form of the question and the abstract that is in plain language, describe what it is being accomplished. That's what we receive. With the Constitutional Convention, it's a little easier since the Constitution says the form of the question. But for so the two is the Constitutional Convention, the second is the public pension ballot proposal. So that language is here. It's posted. We'll get comments at some point before the deadline, which is 3 months before the election. The four of you will need to approve by majority vote a set of words that we can then give to the county boards and translate. So that's working. I think we've had the cooperation of the Attorney General. Todd and I have reached out since January and February when the words were known to us to try and get the advice of the AG. This is the first time we've got it this early, so that's helpful to us because it takes a long time for all the parts to come to be so that we can translate it. Well, one, have a version that you're comfortable with adopting, then translating it, and then getting the legal notices published, which we have to do before the election. All of those steps surprisingly take a lot of time, and the AG's office was very amenable to try and get us the advice early. So we appreciate that. We had the special election on May 23rd. It went very smooth. We had our staff for to support it. I don't think we had many calls that day, but certainly the evening to post the election results, the unofficial election results to the website worked very well in 89 and SD 30. We received one certification already, I think from Nassau County. We're waiting on the other two soon. It is the wind down of the legislative session, but just one little report of the 22 bills that are in our annual packet. 15 at least have a sponsor in one house or the other or both, which is pretty good for us. We keep working on the other couple of bills that haven't quite gotten a lot of excitement yet. 2 bills have passed both houses so far. Split shifts for election workers, give them a little bit more flexibility instead of requiring half-day shifts. It allows split shifts, so of any portion during the day. And a proposal that you championed, Commissioner Spano, candidate contact information on the website has passed both houses. So our proposal 8 and 9 have passed. 3 others have passed the Assembly and still being considered. The ED size to go to 2,000, alternate poll site organization, and streamlining to deal with the poll watcher. Before every election, we get a lot of calls at all ends of the building about what does that section mean. It just makes it clearer what we've always interpreted it to mean, so that hopefully that guidance would go out to people and we would get fewer calls. But that's only passed one house so far. One bill has passed the Senate, and that would reform the legal notice. We still require the legal notice, but that notice that is required to be published 6 days before the election no longer would have to have the candidate address. It's not really useful information that late in the season. Nobody's really making a decision on voting for or against anyone because of their candidate address. That would be more helpful information around July when they're filing their petition, maybe. But that's passed the Senate. Hopefully it'll move elsewhere. So that I thought was a good sign. We had a monthly call with the Election Commissioners Association last week. One topic that came up was quite an interesting discussion. Was certainly the rules by the Reform Party that are being litigated, but we wanted to at least raise the issue with the county that the Reform Party rule, a Reform Party rule that's filed with us has a requirement that allows non-enrolled voters to vote in any primary for public office in the Reform Party. So at least to let them know as they prepare for the September primary that that's a possibility. And we did explain to them that there's ongoing litigation in regard to that, but at least they should be prepared. It does raise a number of policy issues, especially since the Independence Party also allows non-enrolled members, so how to administer that will be a big topic.
There's a difference, though. One is for certain offices and one is for all offices.
Correct, but they both allow little county committees to go beyond that. So the Independence Party is for certain statewide offices, the Reform Party is for any public office, but they would allow, the Independence Party rules allows a county committee to go further than that for local offices.
So you're saying that the Independence Party allows non-affiliated voters to vote in their party primaries?
Certain.
And the Reform Party also is allowing that? So if I'm a non-affiliated voter, can I vote in both primaries?
That's a good question. And we have discussed that. We are working on an answer to that question, and I know our esteemed colleagues in the council's office will have a lot more to say on that, but
That raises the
Not
question,
really, it's a
too,
good
because
question,
It's up
yes.
to the party when you have open primaries, correct?
uh-huh.
So suppose the Democrats and Republicans decide to do that, can you vote in 4 primaries?
Still a good question.
Times two.
Yes. Magnified question.
Also a good question is the contrary. If they can't, how do we organize which one you pick?
Right.
It's easy for in-person voting. It's harder for the per-mails who already have an application. The statute says send them whatever ballot they're entitled to. How do they pick which one to send them? Same way with absentee voters. Our current application doesn't really have a select what one to send me. So do we send them all and tell them to pick and only send us one back? There's a lot of policy questions we have to get our head around real soon. So just like we told the counties they should work to prepare this, so should we. I wish we had more answers for you,
No,
but
this-
we've been
this-
thinking about
this-
this since last Thursday a lot.
Whether this extends itself out to Democrats, Republicans, and every other party is not the question here. The question is if everyone starts doing things like this in piecemeal, and it raises all kinds of complications. And maybe we should take the lead in developing something that we suggest to the legislature or something to take care of this before it gets out of hand. Because you have one party that said, okay, we're going to do these offices, but if you're a locality and you want to do more than those offices, okay, you get another party saying, these are all the offices. You got potential of other parties saying some variation of all of those. It wreaks havoc in the whole system.
Yes.
Yes.
Well, I think, as I understand it, there's limits as to what the state can do to regulate what a party chooses to do. I believe some of these rules have emanated from court decisions, which have said parties have the right, despite state law, to allow non-party members to vote in their primary.
Well,
So, you know, the way the parties configure themselves is largely determined by the parties themselves, and I think there's a limit as to what the state can actually impose upon them as rules and regulations.
but we have a constitutional convention possibly
Well,
next year.
well-
I mean, the year after.
Well, that's a different, I don't know, I don't know if it could be addressed there or not, but I think there are constitutional issues here, because I think it's a First Amendment right to associate that the parties have used to give themselves this authority. So I think there's some powers that the parties have that allows them to self-determine.
What the powers are. I mean, they have those powers, fine. Then you have to put some order into the chaos by developing another way of handling that.
But until the parties actually tell you what they're doing, it's hard to develop rules. I guess that, you know, because apparently the Independence Party has a different set of rules than the Reform Party, even though it's on the same topic. So it's hard, I think, for us to develop rules when we don't know exactly what the party rules are going to allow.
Okay, but I don't know whether the constitutionality extends to the point where you can vote in anybody's election if everyone has this system of open primaries. That you can address. I don't think.
I don't know. I don't know if you can. Maybe you can. But I mean, we'd have to look at that. But, you know, whether we could tell the Reform Party, if people vote in your primary, they can't vote in the Independence Party, I'm not sure we can. If the Independence Party says we don't care, we want them voting in our primary, even if they vote in another party's primary, I'm not sure the state can say no.
I think the only issue we would look at, I don't disagree with anything you have said, but from the policy point of view, do you give them deadlines? Right now, we have certain deadlines in the statute that if you're going to make a decision like that, you at least have to let us all know to prepare in time for the election.
Yeah.
It's hard to put that in place now for this fall already, but if they intended for people to only vote in, non-aligned people to only vote in their primary, because that's the group, that's not what their rule says. That says any. So I don't know if that's what they, if that's what they mean, maybe they'll amend it. I don't know.
By any, you mean unregistered?
Non-enrolled.
No.
Not enrolled.
Okay.
Nobody has a not registered, but the,
That would be really difficult to administer.
So anyway.
Okay.
So that was, we shared that with the counties. That was certainly
Automatic registration. Okay.
a lot of interesting questions. That's what we have.
Commissioner Spano and I want to report that we have reappointed Bob Brem for an additional 4-year term.
Thank you.
Congratulations. And then I just wanted to make a note that with respect to the website posting of the Attorney General's proposed text, that I raised a comment after it had initially been posted where they both said, where one said question 1 and the other said proposition 1.
Fix those since then.
Well, they've left it blank. I'm still not happy with how it appears. That 7-110 of the election law says that has a form of how ballot proposals appear on the ballot, and every one starts with proposal, and then they're numbered consecutively. And it's very important that they be numbered consecutively, and that the counties and municipalities understand that if they have additional proposals, that they don't start the numbering from 1 again, but they start with the next number after what the state has provided. So we haven't determined yet what the ballot order will be, but both of these items that are on the website, in my view, should start with proposal blank, as provided by 7-110. And we'll get into the actual details when we vote on the language, and I understand that people didn't want to do that today. But I just wanted to call that to everybody's attention again, that 7-110 says that everything starts with the word proposal. And indeed, well,
I know when I said we did receive comments, yours was one of them. What we had hoped to do was to take what advice the law said we needed to receive and put it out unblemished, just put it out there.
but
And-
Bob, it isn't even in the form that the Attorney General sent it.
Oh, I think we
You
checked.
tweaked what the Attorney General sent in terms of the headings that the Attorney General used. So it's not even defensible on the
Oh, I
ground
think
that you just did what the AG did.
We'll check them again.
But, okay,
It was our goal to put it out as we received it, so that if people liked it or didn't like it, they could share that, so we had the benefit of all the comments in time for presenting a consensus to you. So certainly we'll continue to look at that. But if we,
When
if we,
legally does the 1 or 2 go on this?
What is the deadline?
No, I mean, is that
August.
something
3 months
we vote
before
for?
the
Yes, we said
How
it.
can you put a number on it?
No, but it should start with the word proposal.
Oh, proposal blank.
Yeah,
and the research that Nick shared with us too is apparently every 20 years, it's been done a little differently, none of which seems to
But
follow
this-
that. Not that we shouldn't start,
but the statute was amended in 1982 in order to,
97, it was the last time.
yeah, but it wasn't done right then, and then you had,
I'm not defending that we shouldn't do it
All right.
right, I agree with you. I'm just saying we tried to put it out as quickly as we could, that we received it so people could comment. And then whatever was good or bad about it, we would have the benefit of those comments to give you a proposal.
okay.
Okay, anything else on that? Anything else to report from the executive? No. Okay, then we'll move on to the council's office. Kim and Brian.
Thank you. The current litigation has taken up a lot of time in the unit. I'll get into specifics on some of those in a minute. We've met with enforcement to try to finalize the process on the dormant committees, and we have sent over the January referral for non-filers. The unit continues to do, obviously, the reviews and the deficiencies. We're finalizing the deficiency referrals to be made probably early next week. We've exchanged drafts on an advisory opinion at the board. We have met with DEMOS and DRNY, two advocate groups regarding various issues that they have, one with the DMV process primarily, and another one with our HAVA complaint process regs. The training unit has conducted 13 training seminars to date, 3 of which have been CLEs. The most recent of which was yesterday, and the day before. We have finalized the legal update, and we have exchanged drafts and participated in calls with the Department of Justice on the Department of Motor Vehicle issues. We have a meeting with them most probably Monday, this coming Monday again. They're coming in person in flock. They flock here. There is a question from the DMV attorney whether or not the meeting is ripe yet, but I presume they will come on Monday to talk about any outstanding issues, but I think we're close on that. With regard to the cases that obviously we've assisted the other units. PIO has a tremendous amount of foils. So there's been some participation with Brian on the regs that we're going to talk about later in the agenda. With the 3 regs that we put out for comment last meeting, they were published in the Register on May 24th. The comment period ends July 8th. With regard to the cases, there was 2, since we last met, there was 2 decisions from the Second Circuit Court of Appeals affirming the lower court, circuit court's dismissal, and that was Davis v. Kaczynski, and that's the gentleman that also wrote the letter on the ballot prop that Bob referenced earlier, and Sloan v. Michelle. Mr. Sloan has made a motion for a rehearing, but we can't respond to that.
Kim, maybe you could just tell us briefly what the subject of
Well,
those
Davis
litigations were.
he wanted to be an independent delegate for the Constitutional Convention, not affiliated with a party or an emblem or anything like that. And Mr. Sloan, well, he had a variety of issues. He challenged the compositions of the board in New York City and here. And he said that we disallowed him on the ballot on purpose. He's representing himself. In any event, he's trying to.
So there was a ballot access.
Well,
issue?
and the composition of the board, that we shouldn't be made up the way we are in a bipartisan fashion. And I believe there are a couple cases that we may continue our conversation on in executive session. One being Parrish v. Kaczynski, which is the witness residency for village petitions, and the other being Water v. Pellegrino, which was a relatively recent case that is going up on appeal, independent expenditure case. And I think that's all that I have. Do you have anything, Brian?
I do not have anything to add to that. The Lauder v. Pellegrino case actually I think is the only one that actually began and has ended in its first phase in the interim since the last meeting. All the others are just continuing in progress.
All right. I did want to talk about one aspect of Lauder versus Pellegrino publicly, and then we can talk about tactics in executive session later.
Okay.
That I'm very concerned about the court's ruling in Lauder versus Pellegrino because it repeats what I think was an erroneous decision a couple of months earlier in the McGrath case coming out of Nassau County. So now we have two Supreme Court decisions that have held that voters and candidates do not have standing to challenge failures to comply with the independent expenditure rules or other provisions of Article 14 of the election law. And I think the decisions are patently erroneous and are based on old cases that rulings were made before the statute was amended to put in place the prohibitions on expenditures that are now contained, particularly with the adoption of the independent expenditure rules. The court seemed to put together language in 16-114 subdivision 3 that ignores the provision that of 16-114-4 that envisions proceedings other than proceedings to compel filings, because 16-114-4 explicitly says a requirement that a bond be posted in proceedings except a proceeding to compel the filing of a statement. Obviously, the standing is not just to proceedings to compel the filings of a statement, but for any other violations of Article 14 of the election law. If there were only that type of proceeding that was authorized, there'd be no need for the undertaking language. And in my view, the court is also incorrect that the only remedies available are civil penalties in 14-107A or 14-107. While those sections include civil penalties that apply exclusively to those sections, there are other potential penalties that are envisioned by the text, but not just in 14-107 and 14-107A. Specifically in 14-126, there's a provision for penalties for excess contributions that would include so-called independent expenditures that are coordinated, and also include possible criminal penalties, both for misdemeanors and felonies, depending on the mens rea of a violation of the independent expenditure rules. And the new subdivision 8 in section 14-107 cross-references the mens rea in 14-126 which further supports the harmonizing of all the penalties that can be imposed. As case law develops, I envision a claim by a candidate or 5 voters who use 14.114 to prove coordination and convince a court to require a refund of a contribution pursuant to 14.126.2. That is a remedy that I believe the legislature specifically anticipated, in addition to the 2 other remedies, which are a proceeding by enforcement counsel who can seek a civil penalty, or by a prosecutor who can bring criminal proceedings for the violations. And so I think that it is essential that we, as the commissioners of the Board of Elections, go on record to support this interpretation of the election law, that a candidate or 5 voters does have the right to go into court to challenge violations of Article 14 of the election law, and not just adhere to the holdings in the McGrath and Louder cases, that the only time voters or candidates can challenge under Article 14 is a failure to file. So we can discuss the tactics of how to do this in executive session, but I hope that the commissioners will agree with me that this is an important issue that we should go on record on our interpretation of the statute.
Okay, so we'll talk about that more in executive session. I think we've already been in court on this, is that fair to say, with the position?
Yes.
From the agency
Yes.
standpoint, yeah. So I think we've already set out our position. I mean, I beyond the statutory references that you made, I think there's a broader public policy issue at play here as well, as far as the ability of someone, a candidate or a citizen, a voter, having the right to go in to challenge someone's activities during an election, which would include an independent expenditure committee. So I think there's a broader public policy question at play that should allow voters to go in, because it's impacting potentially, the election that a voter is participating in. So I think we've already been on record on this, but we can talk about it more in executive
I
session.
appreciate that
Yep.
comment. And I guess I should just also add that I don't necessarily agree with the substantive claim being made in Louder, but the court didn't rule on the substantive issue. They simply said they don't have standing, and that's my problem with the case. I probably would have ruled against the petition as a failure to state a cause of action, but that's not the issue here that the court ruled on. They ruled that they don't have standing, and I think that's very problematic, that we should not restrict the ability of candidates and voters to go into court to enforce compliance with Article 14.
Okay. Any other comments for the council's office report? No? Then we'll move on to election operations. Anna Savitzer.
Thank you, Commissioner. We have a monthly report in your packets, but I will summarize it for you. We've received party calls from 5 parties. Those were sent on to the county boards. Party calls identify for the public, the interested public, and the boards, how many persons can be elected to judicial delegate and alternate delegate positions, and also state committee seats, if indeed there are any. The party calls identify that information for the boards. As the others come in, we'll certainly send them on to the boards so that they'll have all the information they need for the petition, the ballot access season that's a month away. We have our de minimis decisions from SLI. Dominion is replacing, because they're no longer available, off-the-shelf laptops and handheld accessibility pads for the ballot marking devices. we're doing functional testing on those, but there's no vote of the board required. We're required by regulation to just inform you of that. But we are doing functional testing, and we will be in touch with boards that are purchasing any new equipment to make sure that they are on board with the latest off-the-shelf versions. We have been working with IT on the campus upgrade. We continue to do that. We've also participated in the monthly phone call, as everyone around the table, with our county boards. We collected absentee ballot information and results from the special election that was held on the 23rd. Monday is the last day for military ballots to arrive at those boards, so even though they have preliminarily sent certifications to us, they're going to notify us on Monday if those need to be amended or not. So at some point, you'll have a Board of Canvassers meeting, perhaps next time you meet, because they can take, the Senate and the Assembly can take the results that have been provided by the counties involved and seek the winners of those two contests. The two contests were the 9th Assembly District and the 30th Senate District. We are working on, what was our latest project? We work on a lot of things every day. We have a lot of points of focus. They don't want from us. We have some new commissioners that may be coming to Albany for commissioner orientation.
We've been involved with the cybersecurity
Right.
stuff as well.
Brendan and Bob Warren have been participating in those meetings, helping to identify county board risks and the kinds of questions that boards should answer, and be posed in a way that boards can answer them without reaching for a dictionary and 2 IT directors. Some of the questions are for the county board IT departments, because that is obviously where boards might be vulnerable, but some of the bigger boards do have their own IT operations in-house, so we're contributing to that discussion with Nysboe and Bill Cross and others. And we have nothing new to report. We did amend our Supreme Court vacancy list. There was an additional resignation in was it the 7th? So that was amended and sent out to the boards in that judicial district. And I believe that's it. Brendan, do you have anything you want to add?
I do not.
Anna, are you going to make a presentation about the Albany School Board ballot issues?
I can do that now or under new business, whatever the board's pleasure is.
Not on the agenda.
Yeah, I think we were going to do it now as part of your report.
Okay. We do have copies of a ballot that, for some reason, was problematic in the school board election in the county of Albany and the town of Bethlehem at the election that was about a week and a half ago. We are efforting getting additional sample ballots from Albany County. There was some discussion that the ballot layout contributed to the problem. In our discussions, Brendan and I spoke to the County Board of Elections, to the commissioners there, and the ballot in this particular school district was repeated throughout the county. There were no other school districts that had the same problem. So we are looking at their ballot composition. We are also getting sample ballots from those other school districts in Albany County. We're also going to get sample ballots from other counties so that we can come up with some advice, best practices, if you will, on how school boards ought to build ballots that lend the same kind of consistency we aim for in our own ballots in municipal elections to those school board elections. They run their own elections, run their own show, they have their own formats that they want to follow, but we'd at least like to be able to identify for them some areas that are problematic. This particular ballot in Bethlehem School District, we are also going to get the ballot images for the ballots that were cast. We understand there may have been people who were handing out sample ballots that were mismarked. We understand there was a lot of discussion about the candidates. There was a lot of bullet voting that went on There was a lot of write-in voting that went on. There could have been some debris on the read heads of the scanner that made ballots be determined to have write-ins on them, but when the board actually looked at the write-in ballots, there weren't. So we're going to try to get those ballot images. We're reaching out to the school district because the county board doesn't run the election, but the ballot images are school board elections. So we just want to make sure the school board understands why we would be looking for those, so that they have the right permission to grant access to those
School board
images.
does their own thing, I understand it, and they didn't, in this situation, didn't they go to the county
They-
for final approval, and then frankly just went ahead with what they wanted to do?
Our understanding from the commissioners in Albany County is that the school district sent the ballot, sent the format they wanted, the county configured the ballot, and then the school district does take it to its own printer. The Albany County Board provides them with information concerning the printers that are available. Obviously, the two that most of our counties use. Some of the local county boards print their own ballots, and they have also printed for other counties. So we're going to determine who actually printed these ballots in case that might be a conversation we need to have or want to have. To try and narrow down exactly what the issues are here. For example, we're uncertain why all of these sections on this ballot are called propositions. Why Proposition 1 and 2 are school district ballots, 3 and 4 are library elections, and then 5 is another school district issue. It's hard to read. The issue with all the write-in boxes is one that all of our boards have, and we have this conversation every time a primary election is set up. You can vote for 3, but yet there are all of these write-in boxes. Our county boards have had a lot of arguments with, maybe not argument is the right word, but discussions with candidates when there is a field this large and the write-in boxes only appear under the first 3 names. Why are you encouraging people to write in against me? Or they'll put boxes at the end for the last 3, and those 3 people are complaining to the county board about the positioning of those write-ins. So a lot of county boards do have write-in boxes all across the contest title. It does create issues. It creates a lot of discussion. They have to have those fights locally. And I think they look for the path of least resistance. That's not always what we recommend, but they're the ones that are dealing with these people on a face-to-face basis. So we need to look at that whole write-in issue. But in any event, we're freshly into this. We understand that there are issues, how school districts build their ballots. Maybe they wanted them to still look like lever machine ballots, whatever their issues are, but we think we need to provide them with some direction so that the direction they give the county board is a little more consistent with what we understand an optical scan ballot to be. It better reflects some of the usability issues that have been identified by good government groups as to how our ballot should be changed. For example, this particular ballot, the usability instructions that we provide our county boards are that the names are flush left. The statute says they're all capital letters, but we tell boards to use upper and lower, even though the statute doesn't necessarily support that position. But we have tried to incorporate those kinds of tips to our boards when they're building ballots. We send out a sheet of instructions to boards. It's a copy of it is with your packet. We look at the ballot when we certify it. We look at issues that we need to clarify with boards. For example, that numbering of the propositions. We always let them know these are ours and yours have to start with this numbering system. You can't renumber everything on your own, that kind of thing. So we're looking for best practices for the school boards, and that information, when we collect it and present it to you, somehow needs to find its way to the school boards. I think telling our boards how to build a school district ballot is preaching to the wrong choir. I think the school districts need to know what these usability issues are, what ballot layout issues are, and what better constitutes a more consistent ballot for their voters. I think that's a problem we have whenever people other than us run elections, and until the day we run them all. which I would hope was soon, it's always gonna be a problem. But that's what we're efforting, getting sample ballots from the rest of Albany County's districts, getting them from neighboring county boards for their school district elections, reviewing everything that we get. Phil Jorzak is here. He's with Joe Burns, were our two usability staff members to review ballots when they get filed with us. The county boards do send us their ballots prior to the election. We review those for really egregious errors. We review their instructions. Sometimes boards put absentee ballot instructions on the election day ballot, that kind of thing. Brendan is going to be picking up where Joe left off, but last year was a tough year to get him into a new field of expertise, so we're hoping to do that this year with a couple of workshops that are coming up with the usability good government groups, and they can attend those and pick up some firsthand information and bring it back, and we'll apply it as best we can to the tips that we get for boards and present them to you if you want to go further with them by way of a regulation or a board opinion, a formal opinion or a decree of some sort that would trigger more compliance with the kinds of issues that we continue to raise and have not been successful across the entire state in applying them. We did provide you a copy of the newspaper article.
I want to thank Anna for that report. I think that this is a very important issue in terms of training and professionalism of our election community. That we need to emphasize the importance of usability and to be focusing on usability principles. As the election professionals, we need to have the training ourselves so that we can identify potential problems in formulating ballots. And then we need to provide assistance and services to the counties and in turn to the school board community to help them implement those principles. There are half a dozen things that are obviously wrong with this ballot, in my view, that can be a teaching experience for people who design ballots. For example, to me, one of the strongest things that's wrong with this ballot is that there are 5 sections to the ballot for the propositions, but the heavy lines are not uniformly separating the sections. And indeed, you have the same heavy line bisecting the 2 propositions that are voting blocks for candidates, so that the 5 blocks themselves are not separated, and the idea of putting the heavy line between the candidate name and the write-in box misleads the eye in terms of how the sections are. And then Anna has already talked about some of the other issues with fonts, with having more write-in boxes than the number of write-ins that are allowed, and the layout in general. But I think it's very important that we have Brendan and Phil get as much training as they can on how to identify usability issues and to beef up our own presentation for the benefit of those who are designing ballots so that we can have the most user-friendly ballot possible.
Well, I don't think we disagree that having a user-friendly ballot is our goal. I'm not sure myself exactly what happened here. I read the article. I'm a local guy, so I was familiar with this because I read the articles locally when this all came out. Anna, you're sort of alluding to the potential that there were sample ballots out there that were not helpful, that
Well-
might have actually been confusing to people? Is that what you
The-
think part of the problem
The
was?
commissioners in Albany County thought that that might not be the only problem, not be the problem, but certainly contributed to it, that perhaps someone had mismarked a sample ballot and distributed it 100 feet away from the polling place, but handed it out to people.
Yeah.
And colored in the oval for, that appears on the write-in line rather than the one that appears above the candidate
Well, it appears
name.
the problem, at least as I read it from the newspaper, was limited to the candidates and the write-ins. Is
Right.
that correct? I mean, there weren't problems, as I understood it, that referenced the other parts of the ballot. The problems seemed to center on those school board candidates and the write-ins, and people were filling in bubbles for write-in and not filling in any name.
Well, the number of write-ins was, I think,
Was very
overwhelming.
high,
That's
yeah.
what triggered,
Yeah,
you
that's what
know,
I got too.
some scrutiny there.
So why that is, I don't know.
And the heavy line, may have been part of the problem.
Maybe.
But I'm not necessarily faulting that particular contest. What I'm trying to do is to use it as a teaching moment where we ourselves look again at the need to focus on usability issues and ballot design issues and share that knowledge with other people who design ballots, whether it be the county boards or whether it be school boards and the education department, just to alert them to how to
do it the right
do
way.
the best, how to do the best design.
All right, fair enough.
Yeah.
We do a report card on our own ballots. When the samples come in, they're reviewed by our staff, and we have a checkoff list that resembles the tips document that we shared with you. So that we're looking at every ballot to see if they've applied rules, if they've done something terribly wrong. We call them right away, but we do review our own ballots that are submitted to us and come up with that report card so that we can reach out to boards when we do our on-site visits and talk to them about those issues and see if we can't get them to see the light a little bit brighter than they're currently seeing it.
Okay.
Thank you.
All right, thank you.
Thank you.
Okay. Is that all? Is there anything else from your unit?
We have nothing else.
Okay. Then we'll move on to NVRA, PIO, John Conklin.
Thank you, Commissioner. The Public Information Office has been very busy since the last Commissioners meeting. Lots of calls. Everybody's always interested in campaign finance filings. The special election on the 23rd was very busy. In addition to that, Tim alluded to it, we had 77 FOIL requests in April and 108 in May. Tom and I participated in the monthly ECA calls in April and May as well. We've also been attending the cybersecurity assessment meetings that a lot of other people are involved in as well. I will discuss this. I promised this at the last board meeting. I want to show you that there is a copy ready.
I'm sorry, what is that, John?
This is the annual report.
Oh, okay.
It is completed but for one unit.
It's in editing.
Okay.
Should be done. I tried to have it done for today, but the editing wasn't finished.
So
It will be done.
I know we've discussed that at a couple of meetings now, so I wanted to make sure that you're aware of the status of it. For the website, as we already discussed, we posted draft language for the ballot proposals. Just to add to that, I understood all the parts that were discussed there. This is what's potential on the ballot so far. The legislature's still in session. There could be additional ballot proposals that come out of the legislature. I think there's at least one potential other one that could be passed that's already had a previous passage through the legislature regarding a land bank and a forest preserve. And there was some discussion about a water bond act. I think that is not going to happen, but there was discussion about it in the legislature and it was reported in the newspaper. So just the two that are out so far, it's just so far, so there could be more until the legislature's adjourned. We've posted results for the special election in the 30th Senate District and the 9th Assembly District on the website. That went very well. The PIO staff and a couple of members of IT stayed late to make sure that all those results came in. We've also posted the webcast and the transcript for the April 25th meeting. Since the last board meeting, Greg and Patrick visited the Westchester Board, the Ulster Board, and the Washington County Boards for nice voter reviews. That's all I have. Do you have anything to add, Tom?
The only thing I would add is that at the beginning of May, we kind of worked with the IT department to do the National Change of Address scrub that we do every year. It's where we run it against the NCOA database and provide the results back to the counties for processing. We timed it so that they can benefit from the CAS certification list that gives them discounted postage when they do their August mailings. It's a 90-day window, so we try to do it as early in May as possible, but so that the 90 days from that date will still give them to the last day they're allowed to do the mailing per the statute. On top of that, we worked with a handful of counties to get their military ballots up for the village elections using our system. And lastly, I visited Fort Drum last week to attend a voting, the installation voting assistance officer was giving a presentation to the unit voting assistance officers, the different soldiers in all the units who are responsible for helping soldiers from their respective states get access to their ballots. So I was happy to attend that. The commissioners from Jefferson County also attended that. We had the opportunity to speak to some of the soldiers who are taking on those duties, to thank them for their service and to offer our service as a resource. So.
Anything else? Any questions? Okay, thank you. Then the next unit is ITU, William Cross.
Good afternoon, Commissioners. I'll start with projects. In terms of Capus Fidus, we've made some good recent progress. We're developing election and political party configuration functions and developing use cases for petition filing and candidate maintenance. We've also completed test cases for the election function and working on test cases for the political party functionality. The project still remains in need of 2 additional development staff. I mentioned last month that condition for obtaining those staff was that we submit a project plan and budget to ITS and for DOE approval to sub-allocate funds from them to us to pay for these positions. We did that and ultimately have received that approval for at least a portion of those funds. So we are moving ahead finally with the ordering process to get those additional hourly consultant development resources. That said, that process still takes some time as well, but we're really anxious to finally move ahead with that. That's been stalled for quite some time. In terms of Nysboe, we're continuing to work with the vendors for the refresh project. We're nearing completion of the planning and design for a whole new infrastructure, including networking and servers, disaster recovery between here and our DR site, redundancy. We've started some acquisitions with that regard, and we are actually starting to roll out some of the pieces of that new design where acquisitions aren't required. For instance, on site here. Move unit, I think I reported last month as well. We've started development of an in-house application to replace the currently outsourced military and overseas voters application. Security has been a hot topic this month. So much of there's a lot of news about the ransomware and WannaCry, infections across multiple corporate entities. The state undertook a large effort to ensure that everything is protected, including Microsoft issued actually patches for some older servers and older environments that they don't normally issue anymore. So my group did make an effort to make sure that everything we had was up to date and we were covered. We had no incidents as a result of that. We mentioned a couple times we're working with NYSTEC and the New York State Elections Risk Assessment. Current activities are focusing on this questionnaire for the counties. I think mainly I should stress that the results of this initial questionnaire will really allow us to define and prioritize what we look at next in terms of areas that need further attention for election security. There's a New York State Cybersecurity Conference being held next week, the end of next week, June 7th and 8th in Albany. DOE will be participating in a panel discussion along with representatives from SUNY, Homeland Security, and Nysboe. We have a our annual Microsoft support renewal is up in July. We have a resolution to the board for the portion of that, to fund a portion of that this month. As you probably noticed behind you, you have a new addition.
Captain
So
Kirk.
you can't miss it. So the media capabilities for the boardroom and the law library have been upgraded. The project's still a little bit of work in progress. We're still working on some pieces of it. But in short, it replaces the old projector and screen that we had. Provides whiteboard capability that you can save your whiteboarding for and email it and print it after. Along with full audio and video conferencing capabilities. That's the portion we're still working on. It's our hope, not only to make meetings more productive, but also help increase outreach to counties and use it for interactive training. Possibly eliminate some travel as well in the process. Website stats are pretty much normal. Everything that they've leveled back up after the general election. There's nothing significant really to report there for that.
Any questions? Bill, I have a question. Any update on the timeline? I know that keeps coming up, but I wanted to bring it up. But anything new on that as far as you're concerned?
Well, I didn't wear my Kevlar, but so.
No, I'm just asking. I don't mean to be.
New project manager has come on, and we've tried to pull together the pieces of where we're at in a lot of these pieces. It has remained difficult because we don't have all the resources we need to do it. But based on resources that we do have, we have projected it out in total, including testing and rollout and follow-up, to be April of 19. We're hoping with the resources that we still have outstanding is to significantly pull that back in. There's also some pieces that were defined in the original project that were to be custom built. I feel that they don't need to be. I think that's a waste of effort. We can concentrate on others. I have some lines of communication with Microsoft and a couple other vendors to use some canned functionality software where we can, or commercial off-the-shelf COTS solutions where we can, to supplement that and not be able to take that off our plates in terms of development.
So you're talking April of 19, if nothing changes.
To complete the end.
Okay, but you're hoping to move it up? Is that what I heard?
We're
Or
hoping to move it up with the resource. We've got these two now. We can start. Obviously, hoping they would start last year. It's been pushed out this long. We finally got approval. But even that, the audit process typically takes a couple months before we get somebody on the chair to do that.
You gotta earn your way to a full life.
I've been trying to fill these resources since I arrived in August, and this is, it's still ongoing.
How long it took to fill yours?
Well, if I don't do it, you may be filling mine too.
We did have 3 tries at it.
Yep.
Okay. Any other questions? No. Okay. Thank you. Then enforcement, Risa Sugarman.
Good afternoon, Commissioners. I did submit the discussions we had last meeting about the proposed regulations on the Fair Campaign Code and the removal of the treasurers. I submitted to both council and to the commissioners some suggested language that I thought would be advantageous. So I sent those to all the commissioners and to council. And as to the Lauder litigation, I think that you all know, it was mentioned in the decision. It is my position that decision by Judge McKay was correct, and I do not believe that there's a private right of action, and it is my intent to file with the court a motion for permission to file an amicus brief. I told Brian that yesterday. He said that he was going to inform you of that. So I guess I won't be at that executive session where you discuss your positions and how you plan to proceed. But it is my position that the Judge McKay and Judge Palmieri were in the McGrath case were correct in their decisions. So we plan to go forward if the court grants us permission to file an amicus brief.
Anything else?
Nope.
When you say grants us, who's us?
The Enforcement Division. We have to file permission since the board is the necessary party
Right.
so we would have to seek permission from the third department to file a brief.
So you would be representing one portion of this New York State Board of Elections,
Correct.
using the resources of the New York State Board of Corrections.
Using my budget, yes.
Okay.
We appeared both at the conference and at the hearing. And it is my position that there is, and I don't think that's a surprise to the board. I think we appeared at McGrath at the conference, at the conference call on the McGrath case, so.
The lack of surprise doesn't indicate acquiescence.
Oh, I understand. I just, and I've not ever hid my position or that's why I told Brian yesterday that it was my intention to file that motion.
Anything else? I just have a couple things I wanted to, kind of old business, I think, that we had. Failures to file. I'm still interested in that topic. I know that in January there were, I think I had numbers a little over 2,000 failures to file for the January periodic, and I'm wondering what the status of those are. Is your unit taking any action regarding those? I believe the last report we got, you were sending emails to some filers asking for their filing, and then you were going to follow up with a letter.
Yes, the letters, I believe the letters have gone out to certain of the committees, my attorneys. I have an attorney now reviewing I don't know how many there are on the list, but the list of those who have several judgments and continue to fail to file. We're reviewing those for preparation to request referrals if the cases are those that we can bring to the board for referrals to either to the district attorney or to the attorney general for criminal prosecution.
So these would be committees that have judgments from years back, I'm assuming?
Correct.
Because you're not really bringing judgments
Correct.
anymore against committees. So these
No,
would
I
be
do not.
judgments from, what, 14, 13, 12, back in those
Yes,
filing
and that
periods?
continue, that are committees that are not dormant, because among the numbers that are included in those 2,500, I don't know the actual numbers, I think that figure is, I would not agree, but there are committees that are included in that list that have 40 judgments that are not functioning anymore. And there's no, there doesn't seem to be, when the computer generates that list, there doesn't seem to be any ability for the computer to know whether the committee is active or not. It's just that the committee has not filed a report, doesn't indicate whether the committee is still functioning. So we're trying to.
Well, I guess that if a committee's not filing, it would be difficult to determine if they're still functioning. I guess that's the whole point of making them file, is to determine whether they're still functioning or not. So. Well,
but if a committee is still on a list and has had 36, perhaps 36 prior judgments, it might indicate to me, or it might be an indication that there's no one there, that there's no function, that there's nobody there that's doing anything, and the committee might be dormant. I don't know, and I don't think that when a computer, when a button is pushed, that there's.
But even a dormant committee has an obligation to file to tell us that.
That's true, but I don't believe that committee, that the resources, limited resources that I have, would indicate that I should be using my resources to again file a lawsuit on a committee that already has 36 judgments. So that's a problem that I have with a computer-generated list, when you can't tell whether the committee is dormant or not. And that's why when I meet with Kim and with Brian and Marie and Bob Eccles, Marie Woodward and Bob Eccles, when we're trying to determine how do we determine among the list of people and committees that are on that failure to file list, which are the dormant committees? How can we determine how we reduce the number of committees that are on this list, so that on a failure to file, a non-filer list, are there actual committees that are functioning, spending money, putting up candidates that we look at and that should be looked at for enforcement
Isn't it easy to determine whether a committee that's attached to a candidate is attached to an active candidate? Either a candidate who's currently in office or is currently running for office, as opposed to, say, a committee that maybe supported a candidate back in 2012, the candidate lost, and the committee may be dormant based on your theory because the candidate lost and is no longer running. Wouldn't it be easy to determine the committees that are attached to active candidates, and thus the presumption would be it's an active committee?
But that's not what's on that 2,500, the number that you're giving, the 2,500.
2,100,
actually. 2,100. That's not what's on that list. You have people and candidates and committees.
But can't you figure it out from that list, Risa? That's what I'm asking.
Well, it's not. It's a method, and it's a process to do that. Some of the committees that are on that list are from 1998.
In fairness, we've discussed dormant committees, and we've been waiting for weeks for the enforcement unit to give us parameters to execute the letters and the process that we've already outlined.
And you haven't gotten it.
And we haven't gotten it.
I mean, it just doesn't seem to me to be that difficult to determine which committees we might agree to being dormant for the reasons I outlined. Let's say candidate lost back in 2010. That situation, as opposed to the committee that I think we'd all agree is active because there's a candidate attached to that committee that's still active. It just doesn't seem to me that's a difficult sort of marrying of information that this agency holds together, because we would be the ones who would know which candidates are running, have run in past elections, because that's what we do, and then we'd also have the list of people that didn't, or committees attached to those candidates who didn't file.
Well, you know,
So
I
I'm
don't
just-
wanna get
I'm just not
into-
understanding why
I agree
that's
with you.
difficult to
I agree, and
determine.
quite frankly, I'm not sure I would agree that Brian and Kim are waiting for parameters from me, but, I'm not gonna get into that argument at this time. We've had our meetings. I wasn't aware, other than one figure, about a negative balance, that they were waiting for other things from me, but I don't wanna get into that argument. Yes, that's what should be happening, that we should, in a 2013 race or a 2015 race, when somebody loses a primary, that perhaps that someone, not me, should say to them, okay, you've lost the primary, please close your committee, so that you don't get into trouble by having, not filing your next 10 or 15 or 5 or 3 disclosures. Because those people get on the list too. Or if you've lost your campaign, if you've lost your election, please close your committee, because instead of just sending, putting a notice up on the website, we'll teach you how to disclose to close your committee. Some outreach. When I get a referral, my people, my auditors, my investigator, my attorneys reach out to the committees by telephone. I understand that there are a lot of committees that you're dealing with, but outreach, person to person, is important. Candidates don't always know that they have to close their committees, and instead. Excuse me?
Because they don't.
Because they don't
Have
know?
to close their committees.
Well, if they're not going to run again,
What if they're going to run next cycle?
then maybe they should be instructed, okay, you can close a committee and open a new committee, instead of
Then they have
always.
to disgorge the funds and then re-raise that amount of money.
Well, what I'm trying to get at, I guess, is if your theory and your practice is to pursue what you deem to be active committees and not pursue those that you deem to be dormant, I'm not understanding why you're not capable of determining which ones are active and which ones are dormant. Because it seems to me self-evident that as I've said, if a committee is attached to a candidate who's currently in office, or currently running, or has run very recently, they're attached to an active candidate, and that should be an active committee, and they should be pursued because of that. And I think under anybody's theory, they're not dormant, and they deserve your attention. And I'm not understanding why they're not getting that attention.
Well, I'm not sure that they're not getting my attention in those circumstances, because my review of the lists that I'm provided is the majority, or the numbers of the committees are old committees from the early 2000s, the 90s, people who have multiple judgments. And some of the candidates or some of the committees, the candidates are in jail. Now, yes, they could get out of jail and they could decide, okay, I'm not going to close my committee because I want to run again.
They have, and they've won.
All right, well, there you go.
Well, not only that, but committees don't have to necessarily continue with that candidate. I mean, committees can do other things, as we know, too. But that's a different argument. I'm just trying to, I mean, as you know, I'm frustrated that the practice this board always undertook of pursuing failures to file is no longer happening.
Yes, I know
And I
that.
think that's a big failure of this agency now,
I know that.
because it's diminished the incentive, I believe, of candidates to file here. And I think that's a very bad message to be sending out to the community, that you no longer have to file here and there's no penalty.
And I
In fact, the
disagree with
penalty
that
may
reaction.
occur if you do file here and make a mistake. That's when you may have a penalty. So
And I
now,
disagree with
so
that
now we're
argument.
having the situation where failure to file may be a better option for a candidate than filing something that has a mistake in it. And I think that's a bad message to be sending out to the election community, that your failure to file is no longer being pursued by this agency, and you're basically getting away with filing nothing. The public now knows nothing about your campaign, knows nothing about your financial filings, knows nothing about what money you're accepting, what money you're spending. I think it's a very bad message, it's a very bad practice.
And I think it's a bad message that you say that, because I don't think the community as a,
I'm not saying anything that's not true, Risa.
No, I think that when a candidate hears a commissioner say that,
Yep.
they say, okay, I'm not going to file.
I disagree. I think when the candidate hears you say that you're not pursuing failures to file,
No,
and you're
they
the
don't hear
enforcement
that
counsel,
from me, Commissioner.
then that is a bad message to
They
be
hear
sent.
that from you.
What they should be hearing from you at this meeting, which is a public meeting to tell people what's going on, is I am pursuing them like we always have to discourage people from not filing.
Now, what they're hearing from me is that I am not going to pursue candidates who are first-time candidates or the same, just like the Moreland Commission says. And here we go again, that the Moreland Commission says that the procedure that the board used, treating first-time candidates the same as experienced candidates, the example they used was Pedro Espada, was not the way to process and to treat campaign disclosure and investigations. So that's how I view that I should approach that. I don't treat first-time candidates the same as I treat those who flaunt the law. And you can look at me like that and you can laugh and smirk, Commissioner Kellner, but I don't treat those candidates who continuously refuse to file or file falsely the same as I would treat a first-time candidate who might make a mistake.
You know, that would be all well and good if you set forth actual principles and then followed them. But what you have just said is basically a falsehood, because there is no principle and there is no enforcement. You have taken a position that is akin to the mayor announcing that it is a misuse of police resources to write parking tickets, so we're not going to write parking tickets any longer. And that's what you've done. You've basically said there are not going to be any sanctions for failure to file unless yours is the kind of case that's going to hit the newspapers. And I think that's a horrible, horrible way to proceed. There are no standards for what you espouse as principles, and in fact what it is just a policy of non-enforcement. But you know what? You're the enforcement council, and the way the law is currently written, it gives you the complete unfettered discretion to do that, and so God bless you.
Or not.
I think we agree it's unfortunate. I think we're in agreement here that it's unfortunate that that's what's happened to the enforcement of the election law in this state. And it's frustrating to us because I worked here a long time, and during those years, we always pursued failures to file because it was a principle that was the most egregious violation that a candidate can make or a committee can make in the campaign finance arena, is telling the public nothing about their campaign finance.
It was also totally objective and totally nonpartisan.
Right.
That everyone was treated the same. But now the principle is that no one is prosecuted unless it's of such magnitude that it's going to make newspapers. But, Commissioner,
Well,
you and I
we
don't
do.
have the responsibility
No, I know.
for that.
I know, but I
There's
did wanna
nothing we
raise
can
it
do
because-
about it except shed public light on that.
Right. Right.
Yeah, I gotta ask some questions, John. I'm
Oh,
relatively
sure.
new to this board, okay?
Mhm.
And I'm listening to this, and I'm saying to myself, like, let's go back to the Espada situation. Right? When let's assume I didn't read the Mormon Commission's comment, but let's assume they made that comment. Now, they make the comment they're treated the same way, but we didn't have an enforcement council at that time, is that correct?
No,
we
we had
did.
one.
Two
We had
people
an
with-
internal one.
With the same powers and the same
Not the same
staff?
resources.
Not the same resources, but
No
but we did have an
resources.
enforcement council
Right.
at this agency, yes.
Who could do what she doesn't?
Yeah, but only the
Yes, in
fraction
essence.
of the budget.
Okay.
Right,
was
which
a
the
smaller
Mormon
staff,
Commission
but-
acknowledged.
So this adds another element of resources that you didn't have at that particular point.
Mhm.
I just want to go,
Correct.
just follow me for a minute.
Mhm.
So that if you looked at a Sparta and you said, well, we want to really go after that guy, you couldn't go after him the same way she could go after him right now.
We didn't have the
We
resources.
didn't have the
to
same
do that.
resources.
Okay, so the comment from the Moreland Commission may have been correct in terms of the resources that were available to them. So now we have a situation where you were able to handle everyone in a similar vein and get to a point where everyone's being handled the same way, but when you had a diversity of situations there where you had someone who was a first-time candidate and someone who was a spotter-like, it was difficult to take it, especially if you had 10 of them, beyond that point, because you obviously didn't have the resources. Now, we have the resources to do both. We have more resources. And I don't know why, at this particular point, we're not sequencing this in terms of time limits. Everything before 2005, everything from 2005 to 2010, everything from 2010 to now or whatever, pick any dates that you want. And apply a plan to get at it. And I don't know whose responsibility that is. But I'm just giving you the way I look at it, I hear it, I see it. I would find we still have the names of the treasurer, we still have the names of the candidate for each one of these situations. I would see how many of them we could find.
And we have their bank account numbers.
Right. And I would definitely approach that. Could be a letter, could be whatever. But someone's got to find them and get that to them and say, this is going to happen if X, Y, and Z. That will quickly get a treasurer to call you or someone to call if the guy's still alive or a person is still alive. And you'll begin to find out who's dormant and who's not dormant. And you use some judgment in that particular case. I mean, it's a guy ran first time, never ran again. Everything's dormant. You let him off the hook, or you let the person off the hook. And eventually you start clearing up all these things.
Commissioner,
But going forward shouldn't be a problem.
But I have suggested to council who have administrative subpoena authority that they could subpoena the records of these candidates and their committees to see if the bank accounts are open and functioning on those open committees. I come to you for subpoena authority. The board has administrative subpoena authority where all of those old committees, administrative subpoenas could be issued to see if their bank accounts are open and functioning. I don't have that authority. If you want to give me that administrative authority, I would be glad to have
But
that.
I think if we look at the history of the chapter laws of 2014, changed the structure, created an enforcement unit that began on September 1, and gave them certain responsibilities, took them away from the agency as a whole, put them in a unit within the agency. What they left with the agency was compliance, to review every form that is filed and to attempt to bring them into conformance if they made an error, and those people who didn't come into conformance to turn over to a separate unit within the agency that had resources to do whatever they wanted with those resources. And since that time, the transparent numbers speak for themselves. Our reports show how many cases have been referred to you, how many times a subpoena has been requested and voted on, how many hearing officer cases there have been. I think we're up to 13 since then. One
There
this
was
year.
16
One
last
this year. So if there was a process, there would be numbers to show it. There would be numbers on our, even though we do them in a confidential setting, we still have a legal requirement to report them. They don't know what we're doing, they just know that we've voted on on a referral, or they know that we voted to authorize a subpoena. So to say that the resources, because we got 0 additional resources to do compliance, 0 as an agency, yet we've completed, last I knew, over 55,000 compliance reviews. So we've done that. 55,000. When those individuals don't come into compliance according to numerous meetings as to what's an acceptable period of time, they do go over to enforcement. To say that they got to come back over here and we have to do all this work so that all that money that's over there to do whatever it is they're going to do should be supplemented by us to do subpoenas to find out are they active or not. That authority under Article 3 is in the separate unit in this
I didn't
agency.
say on the new cases. I said on the old.
That authority changed on September 1, 2014, the chapter law. That's the way it is. To say that somebody else should do it, well, fine, if that somebody should do it if I couldn't get any done. But we're really one this year, so it's not like, I mean, maybe there's a secret plan to get it done, and that it is happening, but all of the reporting that the law requires to happen isn't happening, so I can only assume it's not being done. But to say that we are the reason why it's not being done, I think is disingenuous to the hard work of the compliance unit to have completed a very aggressive approach to do what the law says we are required to do.
I hesitate to extend this, but if I may seek your indulgence for just a brief moment. The dormant committee process that we're undertaking certainly is designed to make a more perfect list and to deal with taking committees that have, for all intents and purposes, evaporated, are no longer in existence to be appropriately terminated.
Excuse me, Brian, is the compliance unit taking on this responsibility?
It is, and it's something that we're cooperating with enforcement so that we have agreed upon criteria so that we're not messing up any enforcement potential activity that may be occurring. But my father was fond of the expression that you should not let a little bit of chaff in with the wheat prevent you from making flour, and many millers in his background. But I think that we are never going to accomplish a perfect list. You're always going to be able to say that for this, that, or the other reason, I should not pursue this, that, or the other one. But if you have a list of 2,100 people who have not filed, and you go through the list and you say, no, I'm not going to go after this one because that candidate is in jail and I don't think this committee is really there. And I'm not going after this one because it's really old. And I'm not going after this one for this, that, or the other reason. At the end of that process, there has to be a residual, and it's going to be a big residual. I do not believe that the condition of the total list is a majority of them are not in existence. But there's going to be a residual, and I think it's a very fair question to say is, what have you done with those? And I am not hearing the answer to that question. So for my piece, to the extent that the compliance unit should be seeking a more perfect list, that we have applied standards uniformly and appropriately to have a process where committees that have not necessarily terminated through the appropriate affirmative process, that we nonetheless recognize that when a certain period of time has passed and they're not really there, we get rid of them. Absolutely, we should do that. But if the standard of enforcement is we're not going to enforce until there is a perfect list, there will never be a perfect list. It is a moving target. I think the question is, what have you done to examine and categorize who and what is on the list, and then what have you done about it? And I have not heard the answer to that question.
Do you have the power, do we have the power to just take someone off the list?
That is always an important question that, as an administrative agency, when you're dealing with a statutory construct, that you have to deal with. But just as the courts have acknowledged the principle of impossibility in certain instances where there's a statutory mandate to do something, when it becomes evident because of the lapse of time and the statute of limitations and the balance and the inability to find anybody associated with a committee, just like with a corporation, there will at a certain point in time in a certain factual scenario come a point where you have to just acknowledge the reality of the non-existence of the entity. But that, and that helps clean the list up over time. The agency has done this in the past. One of the things that we've tried to do is look at the history of this process. I think roughly, Bill would know better than me, but more than a decade ago, a similar process was undertaken. So there is certainly precedent for it. But to your point, Commissioner, I think it is important as an administrative agency, when you're doing something like that, that you err on the side of caution, because certainly the objective of eliminating dormant committees from the pantheon of filers is not to let somebody off, but just to have the list reflect the reality of what's in existence. And I will say that as far as that process is concerned, I thank the enforcement unit for their participation in it, and it's been very productive. But I don't think that it should be used as a shield to say, but for this process, enforcement can't occur, because there has to be a residual. Some
What
may
do
say
you
it's
assume
small.
the
I think it's very
residual
big.
is?
I don't
gotta
know,
pick it up.
because if it's not our process to go through and make a determination on whether or not to pursue enforcement. Our job is to accurately refer to enforcement those that have not filed pursuant to our records. And when the judgment call of to pursue or not to pursue is to be made, that's to be made, with the enforcement council. So we have not endeavored to actually, to do that. What we've endeavored to do is to provide the accurate information about what the records reflect in terms of who's filed and who hasn't. And then secondarily, because there does come a point when the limitations period has passed, we should work to make a more perfect list for compliance reasons, but also for reasons of transparency and people actually seeing what's going on in terms of who's active. Because if we have decades-old committees that are still on the list, and there's no address that we can reach them at, and they're for all intents and purposes disappeared, the limitations period is exhausted to the point where we wouldn't be able to pursue them in any event. We aren't doing anybody a service by suggesting that those entities continue to exist. And so there's obviously a process that should happen probably about once every 10 years, or in terms of your suggestion, Commissioner, in terms of entities that age out to a certain point, where we do this process, and we are moving forward on actually accomplishing that.
You are in that process now?
Yes, we are.
But again, to my point, the issue, we are never going to be able to give a list that somebody is going to be able to point to something on it and say, this one shouldn't be pursued. But that's a decision point that enforcement has to make with the list. And I think at the end of that process, why is there nothing left?
You want to get it down from the numbers that you have right now to this residual where it's you're able to manage. And that's not where it is right now.
What's at zero?
No, it's manageable from the perspective of it's more work if there are entities that are on the list that don't belong. Once you determine that you don't think one should be on the list, you can set it up so that you, even as an enforcement.
So why don't you do that?
In terms of removing the dormant committees, we are working on that process. In terms of exercising discretion as to whether or not this individual's failure to file is worth pursuing or not, is a decision that needs to be made by the enforcement council.
Okay. And what about judgments you already have against people?
We have provided to the enforcement council the entire list of historical judgments, and as it is changed by her staff making entries into the database, it is updated.
So on the process that you're dealing with this through and a number of others, right? Is it moving at a rate that you think is appropriate, or is it too slow?
It's non-existent.
I think,
Virtually
well, I think from
non-existent.
our side, I think we think it's relatively regular.
Regular.
Yeah, I mean, when the filings are due, they do the reviews, we make the
From the
referrals,
compliance
from our
side.
side,
Yeah. I meant looking at that whole process.
Well, on the which process, Commissioner? I apologize. The dormant
State
committee
announcement.
process.
Dormancy.
Paring it down, getting agreement on what the next step is, and moving along, but that doesn't exist.
That process, it's not to confuse issues, in terms of dormant committees, is just about making the list better and reflecting reality. It'll never be to a point where the list is without some entity that the enforcement council or any other reasonable person would decide, I'm not going to pursue this, that, or the other one. But Commissioner Kaczynski absolutely, rightly put it, that list is sortable. That list is in a condition that you can make determinations about which things are active and which ones aren't. And you can, as the enforcement council, apply whatever criteria you want to do that. So it is not as if the work product that we are producing is not actionable, or that it is not easily decipherable.
Yeah, we're talking,
I'm sorry, but, and I think she just referenced her next stage is to look at those with multiple judgments against them that Bill McCann got years ago, and then coupled with new material. We would have no way of knowing she's going to use the old judgments and new non-filing to put them together to go after certain people. So
No, but that's not even a fundamental question. The statement was, we're going to take old judgments, determine if they're active, and not go through the administrative process that the legislature set forth in Article 3, but we're going to ask for a direct referral for criminal prosecution. So you don't even get the compliance review that the legislature anticipated from your failure to file or not to be in compliance. We're just going to make a determination that you don't get that chance. We're just going to send you to the Hooskow. That's what it says.
well, yeah,
That hasn't happened yet.
I mean, we're talking two different categories here, as I understand it. You know, one category is the failures to file, which I think is very easy to determine, and those are pretty simple to me. You filed or you didn't. The second are the failure to comply, and those are more, I think, gray in a sense that, you know, you didn't comply entirely, you didn't fix it, we're now sending you over. I can see those being more subjective because the level of compliance may determine whether or not I'm going to pursue you.
we have worked with them to set criteria, and we
That's
don't
fine, but
say over-
I'm focused myself on the failures to file, because those are the simple
It's
ones to me.
completely objective.
Those are simple to me. I mean, this compliance issue is a little more gray. So I'm really just talking about the failures to file, the ones that haven't filed, have an obligation to file, and are not being pursued anymore. And I'm sensitive to it because the years I was here, we always pursued them. We had a policy of pursuing them uniformly because we felt that it was the fairest way to pursue it. It took the politics out of it. Everybody got pursued the same way. If you wanted to come in and make your case that you shouldn't have been pursued for some reason, make it. You had an opportunity. We gave you a 5-day letter. You could respond to that. We gave you a hearing in court. You could respond to that. So it wasn't like everybody got treated the same. Ultimately, they didn't. People would come in and say, I had a hardship, I'm dormant, any number of reasons why I didn't file, and we would consider that. And that would be part of the resolution. But we weren't up front trying to make those calls because that leads to arbitrary, sometimes, decisions about who to pursue and who to not. Could be political, could be other types of things enter into it. That's not fair, that's not right. It's much better administered as a uniform policy. And my concern is we're not doing that anymore. I think that's a failure because I think that was a very good practice. I think it was definitely something this agency did well. And I always would champion as something this agency did and actively undertook. And now we're not doing that. So that's the reason I bring it up. I'm not going to say I won't bring it up again because I will. But I do think it's something that needs to be addressed. And I think it's unfortunate that we're not making any progress, but pointing fingers from, you know, one unit to the other isn't helping us either. It certainly seems to me that this is now in the bailiwick of the enforcement unit, as it always was. It's just the enforcement unit no longer is a part of the agency like it was before. It's now an independent entity, although still under the agency. And we're not able to continue with our practice. You have no.
I don't know.
No, I know you don't. Reese, you have no other thoughts on
I
this?
don't see why this is so hard. So that's why
I don't either.
to get both of these done at the same time. Well, what's the problem? Not a big deal. If it's a difference of opinion, I could understand that, and if it's a different of approach. But it seems to me that the frustration on the board is evident.
I see it.
And I'm one of those people that believes, you know, one person could be right and everyone else could be wrong. So that you have an inch from me. But I don't see why this can't be solved some other way. I just don't understand it. It seems simple. If we didn't have her and we did it, now we have her with more staff and we're not doing it. That's what I don't understand.
You know, Commissioner, you've.
That's it.
I would say that's a fair way to put it.
Bravo.
think you've hit on it. But apparently, Reese, you have no interest in engaging on this or discussing this any further. You have no interest in considering our concerns
I
or
consider your
addressing
concern.
them or trying to deal with us or talk to us or make
I
some
don't think
accommodation
that's-
here.
I don't-
You're not interested?
I don't think that's fair.
Well, I don't hear any response from you. This is
I
an opportunity to
understand.
talk about this. We'd like to talk about it.
Well, I don't think this is the appropriate venue to talk about.
Okay, so what would be the appropriate venue?
Well, let me think about it.
Really?
Might I suggest that you, number one, after this meeting's over, you sit down with your staff and kind of roll us around. And then number two, sit down with the entire staff and see what we can work out. And it seems to me, a lot of bright minds around here, people have been around the agency for a lot longer than you or me. And, you know, tap into that resource and see what can be done to resolve this. There's no sense of, in coming here and looking at what isn't done and trying to, you know, let's see if we can get something done, move it forward, as Commissioner Spano said. Not that difficult.
Yeah.
But the lines of communication do have to be open. If that doesn't exist, then we really have a problem here.
I would agree with that.
That line from Cool Hand Luke?
Well, then let me see
here.
Failure to communicate.
Exactly.
Well, let me say this, for my purpose, I'll just tell you this then. I intend to bring this up at the next meeting. I'm going to tell you right now. And I would hope in the interim, there's been some discussion and maybe there's been some progress in trying to resolve this within the agency to come to a resolution we can all live with. But I do intend to bring it up and we'll see where we are. Okay. Are there any other comments, questions? That's all of our unit reports for today.
I have a question.
I'm sure.
Yeah, it's been on my mind, so I may as well just ask. I just want a status. This is not directed in negative, positive, or anything else. I know that District Attorney Vance kind of blew that case, the de Blasio case out of the water. But in that decision, he also stated something about it being, violative of the spirit and the intent of the law, and which kind of throws the thing nowhere, but sort of back into our or your jurisdiction. And if you don't want to say it because if it's confidential, I'll understand that. But if it isn't confidential, maybe you have made the decision to pursue or not to pursue in a civil way. I don't know. I mean, it's high profile and so forth, so it's been, are we doing anything? If we're not doing anything, by the way, if that's your decision, fine, that's,
I haven't, I don't think I should be discussing it in open session.
Okay.
Perhaps we can discuss it on a different day in
No problem.
executive, since you're going to be discussing other things in executive session. There are probably time constraints, but we can sit down and talk about it. We haven't, there are issues to
I
discuss.
understand. And just understand, Ron, I
I
have no
understand.
agenda in asking the question.
No, I
Just-
understand.
Okay, that's
It was an interesting letter.
No, it's like frustrating too, because it's like, oh, okay. Got the hot potato. Thank you.
Anything else? Okay. Then we'll move on to the next item, which is old business, and that is the automated audit regulations, which have been old business for some time. But I believe we've made some progress on them, and I know there was a meeting here where we included, I think, Bob Warren, you were part of it, and the Nice Tech, and I know they came up with something, and I know Commissioner Kellner's been very active on this. And we have before us a proposed regulation for the use of independent automated tools, I think they're called. A tool, I believe is the term they used, a
So
tool.
I think this is something like the 15th or the 20th draft.
Could be.
And I have two comments. Well, first I'll start by saying I think we're there in terms of what I'm willing to put up for public comment. I have two minor comments about the draft. First is that I think it should be a subsection of 6210.18 rather than its own separate subdivision. That's pretty minor, but and then the second thing I have is that down in the draft in C2, the number of machine assist ballots to be manually compared. I I have no objection to staff converting my sliding scale table into this fixed table. But I point out that in the first entry, for the less than 2,500, 25 ballots, okay, so that's 1% if they're actually 25 or 2,499. But for small contests, 25 is an excessive number of ballots that will essentially require hand counting of the whole contest. So you may want to consider changing that first line to a percentage, like, or split it into two lines, so that everything under 1,000 would be 1%. I mean,
I see.
I guess what I would say is everything under 200 would be 2%. And then you could go to 1% above that. I mean, that's an arbitrary number. It's totally arbitrary
Well,
when you get down to those small numbers,
yeah.
but,
I think instead of us trying to discuss it here, it's public, I think you made the point, you made that point, and I think it's a good point. But if we send it out for comment,
Yeah.
that point will be integrated, and let's see if we get the same comment.
I tend to agree. I mean,
Okay,
I'm
that's
in
fine with
favor of
me.
approving this, and if we can make changes to make it better, we'll do that when we finalize it.
do you have
So-
a view on whether it should be a separate subdivision, or whether it should be a subsection of
I have no view on that at all.
621018? I mean,
I certainly don't have any.
I would just change this to make this 621018L, which is the next subsection. And then you could,
So L. You'd have to, but you're,
and
I mean, you're
then
gonna
you'd
have to read.
change the A, B, and C
Yeah,
to
yeah.
1, 2, and 3, and so on.
Go
But
on.
I just think it fits better than to have the audits in two different places in the article.
I'm okay with that.
I'm okay with it.
Well,
I mean, I don't feel strongly about it.
We have,
but I
we have a
just-
comment.
Well, the idea was just to separate out, you know, there are really two different types of audits, so that you know, it's certain sections, so that it is.
Except they're not even next to each other.
I'm not gonna change it.
Well, that's a function of the way the regulations are, but it was posted in this section, I believe, because that was the next one that was up, was 6 to
Right.
10. So it's the new, we wanted to make it a new section in order to show that there
But
was a
if you-
difference between the two types, as opposed to one.
Except there isn't really, because almost, it says you have to follow. All right, well, look.
Well, listen, can we put it out this way and then
Put it
do
out
all
this
these
way. That's-
changes
yes,
if we
we
need
can.
to down the road?
Yes,
I don't
we
have a
can.
strong opinion on that. Is there a motion to put this out?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Okay. So we're gonna put it out the way it is, but the staff will look at those two issues and then any other issues that come up during the comment period. Because I think we should try to get this done for this year's election, if possible, for any counties. Now, are we aware of counties that are looking to do this year? Is that correct?
Yes.
So we can get this done.
Yes.
Now, let's see, it's
You'd
June.
have to consider at some point, if we make changes, have to go out for another 30-day comment period. Would you want to consider adopting it as a,
As an
as
emergency.
an
Yeah,
emergency?
I would
right at
consider
that
it.
time?
I would consider it to let the counties use it this year, yes. So, but not yet.
Right, correct.
Okay.
The regulation requires that the board approve a vendor. Do you
Oh, I'm
want to
sorry.
see some guidelines? The,
To approve the vendor to have the audit
Right.
tool?
right.
Okay, yeah,
To
I assume
approve a
we'd
vendor as
approve that
an
like
audit
we
tool.
approve other voting systems.
Well, if you are tested, like using Clear Ballot as an example, as
Yeah.
a central count system, they've been through source code review, we certified them.
Okay.
That is the audit tool, so there wouldn't be any additional testing.
Okay.
It would simply be leveraging the previous testing against your decision to approve. But if somebody brand new came in off the street, we'd still like to see source code review and some functional testing.
Okay.
So we could have NYSTEC, we've already kind of been
Why are
working
you
on that.
raising this, Anna? Is that not in here? Is this a concern you have that this won't happen or something?
Well, that wouldn't be part of the reg, it's just a process that your,
Okay.
the board would agree to consider for approving a vendor. It's either done voting machine testing because it's a central count system and it's all leveraged for approval, or if it's a brand-new company in off the street.
Well, should we make then part of the reg that the new systems will be subject to the same testing proceedings that
No,
a...
you don't want to do that.
You don't want to do
Because
that?
that could be multi-million dollars.
That's too much.
No.
It's too much testing. So
Right.
what level of testing are these audit?
Source code review and functional testing by our staff,
That's it?
right.
So we should memorialize that somewhere, though, so that everybody knows what the rules are.
We have NYSTEC working on a draft procedure, I just wanted to make sure it was something that came back to you.
Is that gonna be part of the reg, or is that just gonna be an internal process?
Internal procedure.
Okay,
That would be shared with the vendor.
okay,
Submit something.
okay. So you're gonna give us something on that
At the
in
next
the
meeting.
future? Okay.
Right.
Well, we need that before we approve this, so we have a process in place
Mm-hmm.
before we approve this, so. Okay. Anything else on this? All right, good,
Thank you.
thanks. Yep. All right, that's all the old business, unless there's something else somebody has under old business. All right, then we'll move on to new business, and this is a resolution for payment. And this is a $35,574 payment to Microsoft. Is that correct, William? Do you want to explain this?
Yeah, this is,
Or are you okay?
Yeah, let's just vote on it.
Self-evident, I
This
guess
is, these HAVA appropriations require a commissioner's vote under the statute, so
It's
that's
to have
why
a
we're.
portion of our annual Microsoft support. Keep the lights on, essentially.
A motion to approve? Second. All in favor?
Aye.
Aye, opposed? That's approved. All right, so that's that, and that is the end of the public meeting, unless there's something else somebody wants to bring up. If not, I will entertain a motion to go into
Our
executive.
next meeting-
Could I-
Oh, next meeting, sorry.
Could
Next
you
meeting.
indulge me for a moment?
Absolutely.
I just want to tell you all that I'm retiring
Oh, God.
the end of July.
Oh, Anna,
I know.
that's a big deal.
It's been a long time, 25 years, 31 doing election administration. Sometimes it's been easy, sometimes it hasn't. I'm not looking at Doug.
And I remember when you came here.
Yes, you were the brand new special
I
counsel.
was here and you were here.
We got hired at you got promoted at the meeting I got hired at.
Right.
And it'll be
right.
25 years in July.
Right. Well, it's a sad day for the Board of Elections,
Well, thank you.
and a good day for you.
I hope. Thank you.
Oh, it will be. It will be.
We've done a lot of good things. Election Ops is a good unit. We've done a lot of hard work, starting with NVRA, all the way through HAVA and everything else that we've been through. But it has been fun. There have been moments, but it's been fun. I will miss it.
You will be, Anna. You'll be
You
missed
know my
by
phone
us and
number.
all the
You're not getting my
counties.
law book. You still have to call me. But
I really want that book.
in my top right-hand drawer.
End of July. Well, we'll see you before you retire. Are you not going to be here then? Is that your intent? Or are you gonna
I'm
be
going to
here?
do petitions with Brendan, and I don't have an exact date. I think it'll probably end up being like August 1st or 5th or something, whenever.
But this may be your last board meeting?
Yeah.
Is that what you're thinking? I mean, if we meet in July, will you be there or you'll be gone?
I'll
Play it by
I
ear.
think
Think about
I'll-
it.
yeah.
Don't commit, Anna.
Yeah.
Don't commit.
I don't know if I could
Get
get.
advice of counsel.
I don't know if I can get through a last
We're
board
gonna
meeting.
we're gonna put you up here on. So you'll always be here. Well, Anna, good luck with that. I think
Thank
that's terrific, and you'll enjoy it. And I retired, and it's fabulous, and you'll love it.
And that's why he's here.
I don't want to come back as a commissioner, but I'd like to still find a way to be involved. So,
Good for you. Good
That's
for you.
you won't be finding me sitting here, but you might still be here.
I can remember, this goes back, pardon me, but a couple of decades. And I was in office at the time, and there was some problem, I don't know, with the Board of Elections in Nassau County. And all I heard was, well, Anna said this, and well, call her up, well, Anna said that, well, we can rely on that, but they went back and forth, who the hell is this Anna? And I got to learn, even there, down in Nassau County, after several years, that whenever they had a question or a problem and so forth, call Anna, or, I don't think that'll go over, if Anna gets a hold of you on this one, you're in trouble. And then when I came here and met you, you were absolutely a delight, so professional, knowledgeable, hardworking. You set an example for everybody.
Thank you.
Can't say enough.
Thank
I'm
you.
gonna miss you.
I'm gonna miss going to Nassau. I spent a lot of time down there. When I started, we talk about all kinds of stuff, and these guys weren't even born then, so it's very depressing. But
That's how, Anna, that's how you know it's time to retire.
I know, it really helped me. You're talking about stuff, and they were 2 years old during Watergate or whatever they were. God.
I wasn't born.
But
Shut up.
Nassau had no computers when I started. I spent a lot of time down there working on that. Boards had no fax machines. But, this is what we were up against then. They had no budgets. Most of them were part-time commissioners, and I think we've really turned a lot of things around, and that's why I think we should run elections. We've done a lot to professionalize the services that our county boards provide. Some of them don't like hearing from me. Some of them are probably opening champagne, celebrating the fact that they won't have to listen to me anymore.
I doubt it.
But my only goal was to keep boards out of court, to make them professional, to make them own up to the oath that they took. And if sometimes they didn't like how I presented it, that was my only goal. This has not been a career or a job for me, it's been my life. And they can take exception if they want to, but I know what we did, what we accomplished, and the ones that have benefited from it, that have stayed out of trouble thanks to whatever it is we've done together, then that's all that matters.
Well, you never had an agenda, except to get the thing done
I never
right.
did. I still don't.
Good for you, Anna.
Well, Anna, we're gonna miss you, so best of luck.
I will miss you all, but
Stay in
thank you.
touch.
We will.
Okay, okay,
Thank you for indulging me.
absolutely,
And thank you.
absolutely. Well, we do have to schedule another meeting, which we haven't done. So, we have one on August 2nd.
August 2nd.
It's already
Okay.
scheduled, so it's the in-between meeting
Okay.
that we'd have to have.
What's wrong with,
How about
why
July,
August
are we
2nd.
talking?
what's wrong with August?
Oh, you
2nd?
just want to go to August 2nd? That's
Yeah.
okay, well, okay.
Listen to me.
I mean, is there any reason we need to meet between now and August 2nd? Is there anything we need to do as a board that you guys are aware of? I guess if there is, you should call us and let us know and we'll
August
schedule
2nd
something.
is the date we know we need.
Right.
With regard to any ballot
Right.
access challenges.
Right.
It would still be timely for the English version of the two ballot props.
Yep.
Is assuming then that the translations would be.
So we would do
after that.
petition determinations from the designating petition time on August 2nd, that'd be
Correct.
timely.
Any challenges,
That's
which
what
is
we'll be planning.
And that won't be much, right? That'll be judicial
It's usually-
delegates and stuff.
right.
Yeah.
It's usually prima facie for this kind of a year.
Okay.
So it's
Okay.
usually a small.
Well, if you don't see the need, I guess we're inclined to go with August 2nd. And if something comes up in the interim that needs our attention, you can call us and we'll arrange something.
Or we could do a web
Which on the big
meeting
screen.
with the
Which
big
on the,
screen.
well, or we can meet here if we have to, but we'll deal with that if we have to. So, we would then entertain a motion to adjourn, to go into executive session to discuss litigation, and we will reconvene on August 2nd. And we will not be coming back into public session today. Okay? So I'll entertain a motion to adjourn,
So moved.
and second, and all in favor.
Aye.
Now this-
We're into executive session.
We were gonna move it into the library.